Well, welcome to Pinal County Board of Supervisors, September 12th, 2024, special session meeting. Item number 1, discussion and seeking public input on potential modifications to the Board of Supervisor procedures and use of call to the public as at Board of Supervisors public meetings.
Chairman, if I may, before we get started, if we can just acknowledge that Supervisor Kevin Kavanaugh is on the phone.
You got it. So we would like to, Supervisor Kavanaugh, are you there?
Yes, I am.
Okay, good. So he's joining us telephonically. Thank you for the reminding. Okay. Mr. Volkmer.
Thank you, Chair, Board. Ken Volkmer, I'm your county attorney. First, I want to thank the board for their willingness to come and have this conversation, to make it a public meeting, to give the public an opportunity to be heard on this topic. I need to start by saying unequivocally, there is not a pressing need that you change the status quo. I'm not advocating that you do, but part of our role as legal advisors to you is to make sure you're aware of what's going on. As I addressed at the last meeting, there have been a couple instances where we've gotten sort of close to violating potentially an open meeting law issue. It's my duty to bring it to your attention. You know, I meet with my civil team, I meet with our team, and ultimately we believe that a work session is the best opportunity to have this conversation. This is call to the public, but it can also be a little bit bigger because call to the public necessarily impacts some of our rules. Sort of the board rules and those type of things. So the way that it's drafted is we have a little bit of wiggle room. We can't get too far afield, but we can have a conversation.
So for instance, where you have modifications to the Board of Supervisors procedures, that allows us some leeway so that we can talk about some of those procedures.
I would prefer that it somehow sort of relate, at least tangentially, to the call of the public, as long as we can tie it to that call of the public conversation. Because we can talk about decorum, we can talk about some of those issues. But if you want to talk specifically about, you know, something completely different about, I don't even know, it could be difficult. But when we're talking about, like, for example, the order that the board wants to hear things, that certainly falls within that discretion of call of the public. The decorum that you expect from all people speaking, whether they are members of the public, whether they are county representatives, whether they are advocates coming in, all of those things can be taken into consideration because it's a big pot, if you will. Does that make sense?
Yes. Okay.
So I think the first thing we need to start with is these meetings, every board supervisor meeting that you have is an open meeting. They are required to occur. You have them more than is minimally required, but we have more business than, you know, Pinal County did, say, in 1912. You know, before perhaps one meeting a month or even less may be adequate.
How do we go to that? How do we get to that point again?
You actually have the ability to do that. I mean, so how frequently that you want to call meetings is exclusively within the purview of the board. In fact, the way it's set up is it's actually the chair gets to make that call. So ultimately, if the chair says, hey, for the rest of this year, we're meeting once a month and that's it, you have the discretion to say that's all we're doing. If you go down that route, I would ask that you give staff plenty of advance notice because we're probably going to be fairly long meetings if you only have one per month. I think last time I looked, we have about seven or eight in the last 3.5 months of the year. But that is something that if the board so chooses, they can go down that route. But ultimately, it's the chairman of the board that would make that call. Every one of these meetings are, again, as I said, an open meeting. At any open meeting, you have the ability to allow a call to the public. You are not obligated to have a call to the public. For those that are listening or specifically interested, you find these meetings under Title 38, 431-01. Under subsection I is where it says, and I'm just quoting it, a public body may make an open call to the public during the public meeting. May is the operative word. I only tell you that, and I'm at this point not advocating that you eliminate it. But if it gets to the point where it has become unruly or unwieldy or not, you're not comfortable with it, this board needs to know that they do have the lawful authority to say we're just not having a call to the public any further. I'm guessing the public will have something to say about that, but I think you need to understand that that's sort of the baseline.
Mr. Chair, just quick, what was the statute again? 38 what?
38431.01, and subsection I is the call to the public portion.
I could only get 38 and I out of that when I heard it the first time, so thank you.
There is some fairly decent guidance that former Attorney General Janet Napolitano gave us clear back in 1999. So it's 25 years old, but it's no less valid at this point. And I'm going to read just sort of a summary portion of what she wrote. A public body may impose on speakers reasonable time, place, and manner restrictions, and that any content-based restrictions must be narrowly tailored to effectuate a compelling state interest. So when you call these, because they are voluntary and because they are in this building, we have the ability to create, specifically they call them, and I want to make sure I get the words right here, time, place, and manner restrictions. If we are going to restrict content, for example, you can talk about this, you cannot talk about this, we have to be very careful. They have to be, again, narrowly tailored, bunch of nerdy attorney words, but narrowly tailored to a compelling state interest. And I'm going to take just a minute to give you sort of some history on compelling state interest, because the fact that we have this has required me to read a number of law articles, law review articles, and including a fairly interesting, like 87-page, tells you how much fun I have, an 87-page law review article that was written about a decade ago, and then a couple more that have been written more recently. But the old one, it actually talked about the history and how we got to this compelling state interest. It's important for this board to know, and it's, I think, important for the public to know that a compelling state interest has changed over time. If you go back to the 50s, think about the Cold War, think about the rise of communism. Our U.S. Supreme Court was very split. It was divided. There were high protectionists for the First Amendment, and there were low protectionists for the First Amendment. And for a period of time, they actually had low protectionists, so essentially saying, hey, the government can restrict it pretty easily. In fact, at one time, there's actually a Supreme Court opinion that specifically says that a government action regarding speech restrictions is constitutional if it is reasonable. That was the standard in the 50s. So any restriction, as long as you could say it was, as long as you could define it as reasonable, you were allowed to restrict it. Then the 60s come, there's an actual change in the Supreme Court. 2 new Supreme Court justices come in. One was very much adamant about protecting the First Amendment. In fact, wanted virtually no restrictions. So they developed this sort of compelling state interest. It starts in a case called Tweezy, I believe it was in the late 50s, and then Tweezy gets cited moving on through. Where we're at now is we have much stronger protections. In fact, any restriction that you want to put on content-based requires strict scrutiny. We have to tell you why there's a compelling state interest in limiting that conversation. I give you that as the basis for sort of the conversation. For example, none of us like to hear critiques or criticisms. If you are going to make a rule that nobody can come and criticize, we're going to have to be very clear on why that is a compelling state interest and why we should do it. Now, I can tell you that there's a Fourth Circuit opinion that suggests that we can, but I'll also tell you that there's ongoing litigation questioning the validity of it. In fact, if you look at today's Arizona Republic, you'll see that our current Attorney General, Chris Mays, is actually looking at the City of Surprises board rules or city council rules to see if that restriction is in fact valid. Now, I have no inside knowledge as to where she's going to come out on that, but she's going to be, I believe, instituting that sort of compelling state interest. What is the compelling state interest? So this is, needless to say, sort of an evolving kind of area. I had mentioned it earlier, I think.
Chairman, since this is a work session,
go ahead.
Can we banter like we do at work sessions?
Yeah.
Okay.
Start bantering.
Yeah, it's that thing in Surprise has gone beyond just the Attorney General. The city's being sued by a group called FIRE, Foundation for Individual Rights and Expression, who's done this all over the country. And I think there's a lot of lessons to be learned from that whole. If you've watched the interaction, I didn't see any reason for her to be gavelled, let alone arrested. And I think that's going to have a lot of repercussions, and there's probably a lot of bodies like us discussing this. So I'll come back to that later. I'll let you continue to make your points.
But the reason why she was being gavelled, if I might, was that they had certain rules that she wasn't following. And that's where so that's one of the reasons why we're having this discussion, because do we want to go down that path like you're talking about? And I'm not suggesting I am.
I'm going to tell a Mike Goodman type story right now. When I was in high school, we had an underachieving basketball team. We should have been whatever, so good. I broke a bone in my foot the night before the first game, battled back, made it back for the last game of the season. The whole season went sour from there. But then we got together afterwards, and we played an independent league, and we were quite good. And one of our players, he was like a Dennis Rodman. He was just a wild man and whatever. And he had an attitude, and if he didn't get the call, he would get a technical. And the refs, you had the same refs every game. And instead of going into every game fresh and letting him complain a couple times, the first time he would complain in the next game, technical. And that's what they did to this lady over there. Because she had been to that board before, they were ready to gavel her instead of giving her her time to speak.
Good point.
And I think they carried that over from other meetings. If you look at what she said, she really wasn't criticizing. And what other option does she have to criticize?
Yeah.
So like I said, I do plan to come back.
That's a good Mike Goodman story.
Okay.
Chair, Supervisor Surtee, and just to be clear, this is not just limited to Surprise. Most of you know I live in the city of Casa Grande. I get the old school newspaper sent to me. They now do it every other day. And if you open up the Casa Grande Dispatch, the front main article above the fold article is something that's going on at the high school board. So essentially there are two gentlemen that are wearing hats that say, "Make education great again." They have concerns. People have complained, saying that that is essentially a substitute for MAGA and its political speech. So there was a decision made by the superintendent, who in a kind of weird way sort of acts, actually be more like the city manager or the county manager, be more like Mr. Liu. So he just decided to eliminate any complaints. There's just no longer video. I'm not using that to bring a highlight. I'm just saying, like, this is something that's bubbling to the surface. So I would much rather us have this discussion now, not an issue come up, the board make a decision, and then us scramble to try and protect it afterwards. So that's why I'm glad we're having the conversation, because you're right. It's happened at city council level. It happened in Gilbert. It was actually our treasurer, Mike McCord, who sent me the link to the Gilbert one, where Gilbert did something very similar. They prevented two people from being there. They had signs. They came up and spoke. They actually kicked them out, and ultimately the town of Gilbert, I believe, paid somewhere near $200,000 out to those people whose First Amendment rights were infringed upon.
I want to interject some other things.
Yeah.
Mr. Miller and I both come from city government, and to go to a city council meeting, just about any city in Pinal County, it's probably 7 minutes to get to City Hall from where they live. I know we have people that drive 30 minutes to come here. So to just not let them speak after driving 30 or 40 minutes, it's a big county. So you get that little bit of a nuance also. And Steve, I'm sure you've seen in your council meetings, and when we go to League of Cities, every council has kooky type people that come up, and some of them spout what we interpret as being gibberish, but they have the right to spout that gibberish, and it may appeal to 1 out of 100 people that are listening to it. And we have people that come speak about national issues. It goes over our head because we're a county board. We don't have influence over, our senators and, but yeah, but it's their venue to reach somebody. So,
Okay.
so I want to keep interjecting as we go.
No, and that's good. I would like to invite everybody to do that as we go through this, because in a sense we've turned it into a special session simply because we wanted to the public to have input, and the only way with a work session that is possible is for it to be a special session. So just be prepared to be interjecting, okay? Thanks.
I got my right-hand man here to my left, so
Okay.
I think we're ready to go.
Lefty.
The one thing that I would suggest, now obviously it's your discretion, Chair, how you handle this, but if you've ever seen one of those decision trees where it's, you say yes or left, and if you say yes, then you go down there. If you go left, you go down this way. The first decision point that this board really has to make is effectively, does it want to continue call to the public? And the reason I bring that forward is if the board has no interest in continuing call to the public, if it's just going to cancel it, there's no point in wasting everybody's time and going through all of the restrictions and those type of things. So the first sort of primary decision is, does this board have the stomach to continue going forward? I'm certainly willing to step down if the board wants to hear from, however you want to hear it, if you want to hear from the public, but that needs to be the first decision. Because again, if you say no, why are we going to waste 2 hours of time just twiddling thumbs if you've already made up your mind that there will be no call to the public? If the board is not comfortable making that decision right now, we can continue to go down. But at some point, the board's going to have to say, do we want call to the public? And then there's going to have to be, what's the timing of call to the public? When do we want it? Do we want to put well, if you want it, and then when's the timing? And then you're going to have to say, okay, what restrictions do you want? Is it going to be 3 minutes, 2 minutes? Is it going to be, are we going to do some content restrictions? It was alluded to by Supervisor Surdy. Are you going to limit it specifically just to issues that the board has control over? For example, you can't control the President of the United States. So if somebody's really mad at the President of the United States, you'd have the ability to say, we're just not going to entertain those types of calls to the public because it's beyond what's in our control. So again, there's all these sort of decision points that you're going to have to make. At least that's sort of how I envision this going, to try and make it as efficient and rational of a discussion as possible.
Okay. Supervisor Miller.
Excuse me. Thank you, Mr. Chairman.
I'm listening.
We decide at some point, we'll have we'll have call to the public. But then I think I heard you earlier that the chair can say, nah, we're done with the call to the public today, or maybe for the rest of the year. Or is it really the chair that dictates that part of the agenda? And then the others are going, no, wait a minute, Chair, we want to have it,
Chair, Supervisor Miller, that's a great question. So at a kind of a big picture, the board sets, hey, these are our board rules and this is the way it's going to go. But individual meetings are actually controlled by the chair. So there is if you say we want call to the public, there's a presumption that call to the public will exist. But the chair can come in that day and just say, I'm not having it today. And unless you agree to board rules to the contrary, and that's where we can get into some of those procedures and rules where, if the chair says, hey, I'm willing to sort of delegate or cede some of that authority to the majority of the board, and 3 people say we want to have it. But the way it is right now, you guys can say we want call the public, everybody could be there. Mike could come in and say, look, I'm hungry, I'm grouchy, and we are not having it today. I mean, it can be, frankly, arbitrary.
Surdy does that already, so but...
I was hearing 2 different things.
So there is sort of 2 different.
Yeah, okay.
Excuse me, Mr. Chairman?
Yes.
If I could interject and hopefully answer Supervisor Miller's question.
Okay.
If you recall, back almost 2 years ago, this November, the board adopted meeting rules of order. And we had debate and discussion regarding what we should include or not include in those. But one of those items that we did include, the chairperson shall have the authority to limit or expand the extent of or suspend public comment or call to the public for any particular meeting, but shall provide an explanation for the membership. The decision shall not be appealable. This is what the board approved and adopted back nearly 2 years ago when they adopted these rules. So you did vest the chairman with that authority.
Okay.
Chair, there is one other thing, too, and I apologize for not leading with this.
I don't even have that kind of authority at home, so this is kind of new to me.
Howard, don't you?
Stay at work.
Go ahead.
Specifically, I think we need to sort of define what call to the public is. Because if you eliminate call to the public, that does not necessarily eliminate giving people the opportunity to come and speak about an agendized item. That's another option. So call to public is sort of twofold. It is to talk about agendized items, but it is also the ability to speak about anything that their heart so desires. So the board has the ability to sort of parse those out. We treat that as sort of one thing. When people come up and say, well, I'm here for item number 2, or I'm here for a particular consent agenda item, oftentimes we'll say, okay, hold your comments till then, and we allow them to speak then. So the board also has the ability to sort of parse out call to the public, saying there's call to the public that is relevant to today's proceedings, and there's call to the public that is arbitrary, or I hate to use that word, but non-related. So there's also that decision that the board has to make. Because if the board just says, hey, we only want to hear things that are directly related to agendized items, you can make that rule, and you can still allow call to the public in that very limited fashion.
That would be my personal choice. Just
public.
because it's germane to what we do. This is our business meeting, and if someone wants to speak about what the business is that we're carrying on, that would be great.
That'd be appropriate.
That would be appropriate. But all the other stuff that goes on,
Some of the agenda items that we do require an open hearing.
It's a public hearing.
I'm not talking about ones that are labeled for public hearing.
Those are automatic.
Even if you eliminated call the public in its entirety, if you
has
have a
to be
public
done.
hearing, you have to allow the public to speak.
Okay.
That's typically by statute.
Mr. McClure, just so that we don't come off as pompous, this is not our meeting, this is the people of the county's meeting, and we need to do their business. Right.
yes, but it's the business meeting that we're conducting, and
Right.
so to hear
On
about the
behalf of
business,
them.
yes.
And so it goes both ways.
Yes.
People, why do we have to do this when we have important business to do for the other people in the county?
Yeah.
Mr. Chairman?
Yes.
If I could maybe elucidate a little bit on what I believe.
Hallucinate?
No, I didn't say
No,
hallucinate.
I'm-
Hallucinate. It's too early for that. A good example they give in some of the open meeting handbooks is if you are at a planning and zoning meeting, and the meeting is agendized just for planning and zoning, our planning and zoning appeals, they also have a call to the public where people can come up and talk. If someone wants to come up and talk about capital punishment, they can be shut down and say, that's not appropriate. We've got nothing to do with that. It's not even on the agenda. So it's those kind of, if you look at it in that kind of a circumstance, what you would limit it. It's the things that are for that body. And that's one of the easiest examples I can give. Zoning appeals board, and you want to talk about capital punishment. It's got nothing to do with one with the other. Now, the Board of Supervisors, you have much broader discretion and so forth than a zoning board does. So I just wanted to give you that kind of an example.
Okay.
Thank you.
I was going to make that announcement, turn your phones off, but every time I do, somebody's phone goes off, so. Miller, could you turn your phone off, please?
So, Chair, I'm not sure how you'd like to proceed. Again, my preference would be whether the board have a discussion about whether call the public is something that
Okay.
is something you would like to continue, because that will sort of set the tone for.
And then part of that, I'd like to hear from the public, too. I think we should. But if there's any more further discussion amongst us about call of the public, Supervisor Kavanaugh, you're on the line. Right? You there still?
There was,
Go ahead.
yeah. There again, going back to the city experience, one of the things Apache Junction did, they used to have it at the beginning of the meeting because there were so many representatives from companies and lawyers and dignitaries in the audience that sometime they had to sit through an hour of call to the public, that they decided to move it towards the end.
Yeah.
There again, you've got people driving all the way from Casa Grande or, top of the world. It may take up their whole day because they don't know how long the meeting is going to go. If they want to just come for call to the public, the meeting may end abruptly at 11, or it may go till 2:30. They would have to sit through that to get their chance to speak. So it's a privilege or a courtesy to the public to let them go first, but you do have that option as well.
Right. And to your point, there's been many times that we've had call to the public that's gone on and on and on. And we've got all of our staff here.
Hundreds of
that's
dollars an
on
hour.
different projects,
Yeah.
and that's a cost to the county as well.
And a lot of these lawyers are making $500 an hour.
Yeah.
So they like sitting out there.
I'm not.
And we've even had it to where. Anyway, Supervisor Miller.
And I think Chris kind of touched on what I've always thought about the call to the public. I want to hear about policy. In other words, if there's somebody that thinks our policy's wrong or want to change something or amend a policy, and that is always tied to how we're spending your money, typically. I mean, those are the back to the business of the Board of Supervisors. Those always do interest me when public does comment in those areas. And to Supervisor Surtees talk about the federal, over the years, I've watched the federal delegation make all kinds of votes, and I'll just use an example. There was a farm bureau or a farm bill that was out there, and a lot of the Arizona delegation didn't vote for it. I was kind of like, that's weird, because we'd really been pushing for this. So I reached out to their office, one of their offices. Well, it came right back to same thing we deal with. Steve, it was the devil in the details. We weren't going to pass it with those details. We got them changed, and then sure enough, then it passed. So I kind of leave that business to them, because I'm not down in the trenches with the feds. And it doesn't mean that I don't reach out to them from time to time. It doesn't mean I don't follow them. But again, back to our call to the public, I like it if they're talking about what we're doing, and I don't mind criticism if it's something we should look at policy-wise and change. So that's just my thoughts about the call to the public and what I try to draw from it.
Supervisor Surtees.
Kent, you already alluded that the chairman has some leeway, and in the 4 years we've switched. All four of us have been the chairman for a year. I once had a state legislator come up to the call of the public. I let him go beyond 3 minutes. He took time out of his day, and I thought that was pertinent to let him speak, because he was we had a different legislator the meeting before. He came to counter it. Wasn't agendized. I think that was fine for the chairman to allow that. What, if you guys remember that?
That was your call, too, so.
Yeah. Just some other little random things. We once had, I think about 6 months ago, we had someone up that gave a complete false name and was critical of, and it came out that wasn't even that guy's name. His name's really this. So you have that situation when here on these suggested rules, you give your name and address. And so we had that situation come up. We don't, just because somebody's up here, it doesn't mean who they are is really who they are, and what they're saying has any fact at all. One thing that's kind of redundant, we ask everybody to fill out the sheet, and this is part of the national conversation, because I'm a media junkie. I listen to all the talk shows. But then after that's all over, does anybody else want to speak?
Yeah.
So we let anybody speak anyway, so it's really not necessary to fill out that form. I think that's more to capture their name and address in case
Well, I
we
think
do
it's-
want to get back to try to help them.
Yeah. I think there's a lot of reasons why Natasha, maybe I could ask you in regards to that. Maybe you'll respond to that.
The reason that we highly recommend for the public to fill the card out is that way we know that we have their information correct in the minutes. It assists us with generating the minutes.
Okay. Spelling and everything.
Yeah, I write down
Even though we
wrong
may
names all
slaughter
the
it up
time because
here.
I don't hear it right.
You can massacre that name.
Yeah,
What's that, Supervisor Surtees?
yeah, that's correct. I write down the wrong name. I think I hear something, and it wasn't anything close to
Yeah.
their name.
Okay.
Chair, to that point,
Yes.
that is a compelling state interest because of the minutes. There are entities that we're aware of that will not allow people to speak unless twofold. One, they have to fill out a card, and they have to fill it out by time certain. Again, I'm not advocating for that, but there are entities that have done
there
that
are-
for that very reason.
Okay, and so there are those type of restrictions that we can put on call to the public if we decide to go that route. That's just an option that we have.
Certainly. Typically, what I have seen, and again, I can't tell you that this is the case across the board, but normally if it's like an hour beforehand, those are usually evening meetings as opposed to morning meetings. Think of a city council that meets at 6:30 or 7 o'clock at night. They'll say, hey, everything has to be in by 6 p.m. before to allow. I don't know of anybody that does it in the morning.
Yeah.
But it is something that this board would have the ability to do, or to create a sort of process where they would have to reach out to Ms. Kennedy.
So the other day I was at a county evening meeting, and they were, the people that would come up and speak would just sign in, either before or after they spoke. But they would come and there was a sheet for them to write their name and address and all that.
Okay.
So instead of just up and gone, would you please step over to the side and, sign in, so that we have your proper
Then
spelling.
we got the proper spelling. That's a good point.
And you
Yeah,
can just,
that's a good way to do that.
either before or after they speak, but just step over to Natasha's desk and sign in.
Chris, you had a comment?
Well, and I was just going to add on to what Kent was saying, is that one of the reasons some of the entities require a submission of your form and your request to speak an hour, 15 minutes, 20 minutes, whatever it may be, before the meeting, it is so the chairman can gauge how many people are out there and how much time should I allocate for a call to the public or to each person. If you had 50, you may want to cut it down to 2 minutes instead of 3 minutes. But if you had 5, you could say, okay, I'm going to leave it at the 3 minutes this time, or I'm going to let these people go first, or otherwise I got so many, I'm going to have to go to the end. It is that discretion that is vested with the chairman, and that's one of the reasons why certain entities cut it off at a time certain before the meeting.
And I would say one meeting that I ran, I forget what the item was, but I had something like 35 cards on the item. It's like, oh my! I said, okay, 3 minutes apiece. We're here for another hour and a half, hour and 45 minutes. So if you can double up or not have to speak if someone already said what you're going to say, please. But that's that gauge.
Yeah.
Chair, there are other entities that, for example, will say call to the public is set for 30 minutes. If we've got 10 speakers, everybody gets 3 minutes. If we've got 20 speakers, everybody gets 90 seconds. If we've only got 2 speakers, you in theory could allow them to speak for 15 minutes. There are different ways that the board can handle it. Those that are really concerned about time, and again, if you have particularly an evening meeting, if you don't start till 6:30 or 7, if you guys are here at 11:30 or 12, I mean that, getting close to midnight, that's tough on staff, that's tough on everybody else. So there's just different ways that different entities choose to address this issue.
Okay.
Mr. Chairman?
Yeah, there he is. Okay. Yeah, Supervisor Kavanaugh.
Thank you. I found the unmute button. So a lot of times in call to the public, people are bringing up issues they've driven to the meeting and they want to have the county look into it. I think it might be a good idea to accept those items in writing, and if it's an item that needs to be addressed by the board or the county manager, let them submit that in writing to the clerk and have her read it. They wouldn't have to take the trip and their business is done. I heard someone talk about an anonymous speaker. I think Benjamin Franklin was famously anonymous. In fact, he had a newspaper and he used a pen name. And sometimes it's necessary when addressing government. I don't know what the specific situation was the other supervisor spoke of, but sometimes in government and throughout our history, it's better that people address government anonymously. So I don't know that even necessitating someone give their name is a great idea. It might be better to just have them submit their topic. Those are my comments.
Okay.
Chair, I would note that that's not unheard of. If you recall, during COVID, we actually had all written comments submitted in writing. Poor Madam Clerk had to read all of those in. Then at some point, we actually modified it to allow her to essentially summarize. And then even at one point, there were 12 in favor of this, there were 7 opposed. But that is certainly something that this board did do during the COVID. So that's obviously a available option as well.
Okay. Is there any others that before we rule whether or not we're going to continue on the open to the public, I think we should hear from the public. Would you guys not agree?
Yeah, we can come back if we have any more thoughts.
Okay. All right. So, do we have any cards? Nobody wants to speak. No, I'm kidding. Yeah, if we could. So, which one? Mr. Rosellis, come on up.
Roberto Rovellis, resident of Gold Canyon. To me, this is one of the most significant topics that can be brought for the public to participate in. And so I was hopeful that you might begin the meeting by expressing to the public how you would conduct the meeting. And the agenda itself does not denote that there will be opportunity for the public to be here. I was expecting this room to be jammed with people, quite frankly, Mr. Chairman. And even though I'm under probably a 3-minute constraint, I think that you have been really opening up some very interesting questions. First of all, the public must be given an opportunity at a convenient time to express itself on whatever topic can be connected to the public business. I think that one of the exclusions that I would make to the public, though, is that there are members of the cabinet, so to speak, of the county, that take advantage of call to the public, informative information, but I think call to the public ought to be reserved for the public body. And if an announcement is important enough to be made by an elected official of the county, it should be agendaized so that all of us being notified can be here to hear that. The discretion of the judge and judgment of the chairman is clearly the key element in how productive call to the public should be. There are, for example, rules that are accepted nationally on how to conduct civil dialogue, truthfulness, respectfulness, timeliness. And with those kinds of cautionary guidelines, I think you are opening up an excellent topic for discussion. I just hope that we are not limited to this one single opportunity to speak on it, because there are a number of other suggestions that I'd like to make. Thank you, Mr. Chairman.
Okay, thank you, Mr. Revelis. You brought up, I was a little bit intrigued by what you said, that the public really wasn't noticed. Item number 1 is discussion and seeking public input on potential modifications to the Board of Supervisors. So I think in the very agendized, it states that we're seeking public input on this. So I don't know why they're not here. We even announced at the last board meeting that we were going to be doing a discussion about all of this. And so, okay, your good brother right there. Yeah, come on up.
Thank you, Mr. Chairman, Supervisors. George Ellison, Gold Canyon. I want to correct some statements made by the county attorney at the last meeting, and basically indicated that you all were close to violating the open meetings law with the call to the public, and he called it his pitch, but I believe it was riddled with inaccuracies. I would agree with one thing he said, and that is that if a supervisor's name is mentioned in a criticism, doesn't give him free rein to have a conversation, but the county attorney needs to spell that out exactly for your benefit as to what you can and cannot say. That's the only thing I agreed with him on. He threw up a number of things. He indicated that the call to the public was an afterthought by the legislature. That's not true. It's in the statute, and it has the same legal weight as any other provision of the Open Meetings Act, and I think Mr. Volkmer will agree with me when you get him back up here. So then the question should be to him, so why did you say it? Because what it does then, when you say something like that, it minimizes the importance of the call to the public. He made a statement that I think was factually incorrect. He was talking about, in fact, the lady's here today, a lady who praised him, and then he basically went into the opposite. He said, and I'm paraphrasing, but we don't let other people tear other people down, dangerously close to restricting types of speech. Well, the reality is the exact opposite of what he said. I've been here many times. You've been here all the time. You've heard zillions of people criticize you all and criticize the county attorney. Sometimes people praise you. That's the nature of the beast. Bottom line is, you allow it. There is no problem with that situation. So why he brought that up is baffling to me. He said another thing to you. He talked about the incident in Surprise. Okay. They're not allowed, based on their rules, to criticize public employees. And he said, though, this board has that same rule. Where? I didn't see it. I don't see it on the card as it is. in surprise about not being able to criticize county or city employees. It's not on our card. It's not on the back of the call to the public. If it exists, it should have been there, and the county attorney should have advised you of that, and it should be on the call to the public, which is handed out to us and which you all attached to the agenda for today, if it exists. Now, he also got into the last time as to whether or not we should have pro or con speeches for particular candidates. Well, it happens all the time here. It's called free speech. Several of you mentioned how you preferred if people just stuck to what's going on with the county and county agenda. I get it. I probably feel the same way. But if you live as we do, as many of us do in this country, millions of us, where speech is restricted time and time again by governmental entities, this is one of the few places where people can get up and talk about something like this. Let's say we want to talk about a national issue. It has nothing to do with you all. I get it. You'd rather not hear it. Where else are we going to do it? Our speech is being restricted all over the country. If anything, you should expand free speech, not look to contract it. Thank you.
Thank you. Yes, ma'am.
Very short. I'm Dee Podolsky, unincorporated Pinal County near Lost Dutchman State Park. And I'm unsure of how this is really going to go. I have ideas on many things that have been brought up, but I thought the first thing we were going to do was discuss whether or not call to the public should exist at all. And that if you don't want to have call to the public, that there's no point in us talking. Well, you're wasting your time, you're wasting our time. So I'm going to only talk about that at this moment. I really believe that call to the public should continue. I further believe that you need to do certain things that we could get into later. But when I was really young and started teaching, I had a colleague who was a member of the John Birch Society. You probably know that's not exactly my political leaning. But we had great discussions. We had fantastic discussions. And he would always say to me, every right has a responsibility. I think that call to the public needs to continue, but I think it needs to be, the speakers need to realize they have a responsibility. And how you would enforce that, frankly, I'm really glad I don't have to do that. I'm glad I wouldn't have to say, I'm really sorry, but that's way out of line. You all have to do that. But I think until we start bringing the discussion back to that rights have to have responsibilities attached to them, we're going to cycle down and down and down and down. And other topics I have opinions on, and if we continue to be able to speak as we go through the decision tree, if that's what you decide, you'll see me again, because once I start talking, you're all doomed. Sorry. Thank you.
Thank you.
That was an example of not being able to hear the name.
Oh, but did we get it?
Good morning, Supervisors. My name's Barry McCain from Maricopa. I'm an activist. I'm a registered lobbyist. And one thing I haven't been hearing is that it takes courage to listen to the public. Now, I've been protesting a long time, but there has to be a parameter. It's about, there shouldn't be threats, but we can talk about it. I never had at Top Gun people who would say, yes men or yes women. They're not going to do me any good. So it takes a lot of courage to hear a call to the public, because sometimes people get up and say things that they're not aware of. They're not right on that, but we have to sit down and talk about the issues. And sometimes when government steps over, like I have in Maricopa, a cabal, and it has to be addressed, or else it can get out of hand. That call of the public is a release that someone can say something and the board can address it as a whole to protect the public. And that's what this is all about, not having controlled speech other than the common sense discourse. You know, sometimes we don't have to agree with someone, but we can be respectful in doing that. And by call to the public, you're able to be aware of something you may not know about and can cause a positive reaction and not a negative reaction based on all the information that you have. And when call to the public comes up, it's to make it aware of something, not being confronted, but just saying this is affecting our board. And it's so important. Everybody I know talks, they listen to the call of public because they want to hear what people have to say. And that's the only way we have a say-so to waylay violence or uncontrolled, unlawful actions. That's how important it is. Thank you.
Thank you, Mr. McCain. Yes, sir.
George Ardondo Coolidge, former council member, city Coolidge, and school board member, so I know and appreciate some of the things that you're dealing with here. These are 3 items that I'll focus on, but I do believe there's more value with the call to the public than having it than not having it, and free speech is important part of that. The threats that come out of that is where I draw the line, and I'm sure you guys have done that. When people speak their free speech, they're welcome to that, but if they're threatening somebody, they are, succumb to those consequences themselves. Talked about time box. I think that's a great idea to keep the efficiency of the school board. This governing board proceeding, whether it's you limit to an hour, at least you have your staff. You can manage your staff coming in here. And if it's more than 20 people, you're going to go from a 3-minute session to a 2-minute session. So I know those are things that were brought up earlier. I think that has some merit to keep that going. Otherwise, at least you control your agenda and how things are going. And if you want to add more time, maybe you defer after that first hour or that 30-minute block, that you'll carry on any additional call to the public at the end of the session. So if people really have a heartburn that have to want something to say, they have to allow the business of the board to continue. And my last thing is consistency of application of the rules. I know there'll be one-offs on occasion, but it's important what you do to one, you do to all of it. I know sometimes we've all clapped on somebody. Those things we need to be consistent. There's been some, not foul language, but disgruntles on the other side as well when somebody was said and comments were made. But we need to be consistent across the board to ensure that we want to hear you and speak your piece. If there's some merit that somebody needs to be recognized, maybe they need to come through the other process that be on the agenda, and so they're properly recognized and duly acknowledged there. So those are my inputs. Thank you very much.
Thank you. Anybody else wish to speak from the public? Come on up. And the reason why I'm allowing this is because the last I checked, anybody that's actually, so are you?
Just wanted to.
Well, many of our elected officials are citizens as well. And so that's one of the reasons why I think many of us that have sat on this, in this position, we've allowed individuals like Mr. Wolf or Mr. Lamb or Mr. McCord in the back there. I'm looking at the 3 of the individuals, and so that's one of the reasons why I've allowed it, is because they are citizens as well as being elected officials. So go ahead, Josh.
Thank you, Mr. Chairman. Yes, and I would agree with you on that very much, to let the people who are not the active 5 members of the board be part of the public.
Can you give your
Joshua
address
Franklin,
and phone number?
Full disclosure, I work for Supervisor Kavanaugh, but I'm here speaking as a member of the public. Just wanted to reference some of our country's original founding principles. One of the things that the Founding Fathers understood well is that freedom is risky or even dangerous. it'll come up in the news every few years where we've got a state legislator who's speeding and gets pulled over, and there's some big issue with the police that, oh, I'm immune, and the citizens don't like it, and a lot of times that legislature loses their seat rightfully. But the reason why the Founding Fathers put that protection from arrest was not that they wanted legislators to be committing crimes, but that they understood that the risks of legislators getting away with crimes in this moment were well outweighed by the risks of having a government that could, falsely accuse somebody, or just, well, we'll have to detain you for now. Oh, you missed your vote. Sorry about that. I guess you're innocent. You can go on. And another aspect that the Founding Fathers understood about the dangers of freedom and the reason why we needed to protect freedom instead was they recognized that it wasn't going to be them in those seats forever, and it's not going to be you guys in these seats forever. So I would just ask, as you're making these rules, think about, what if sometime in the future Pinal's politics changed and we really did have, 3 big despots on this who really shut things down and didn't give a chance, and so for people to speak. And so that would be a thing that I would ask too, is think about how can we protect the citizens who sit under future boards by making rules that have allowance for the citizens to be free to speak here. So, and then a quick comment on the timing. I think the chairman would have authority over when if we have a dignitary here, just to pull that person up to the top, get the dignitary passed. But I think in a way, the dignitary is a colleague and the public are the boss. And I think that would be valuable to consider as we decide on the timing of that. So thank you very much.
Thank you. Is there any others? Oh, Gail. Ms. Peters.
Good morning, and I'm glad you were taking the time to address this subject. My name is Gail Peters. I'm from Santan Valley. I think this is a very valuable thing for our community. I've heard person after person get up here and said, I didn't know where else I could be heard, where I could bring this. I got to commend you guys on your patience in listening to the variety of subjects that come before you. In particular, when we have this entire room and both overflow rooms filled with people here for one subject, there has to be some way to be able to make that more just doable for everybody to hear. And I hope there's some way that you guys can think of dealing with this. It's a very interesting discussion, and so I thank you for allowing me to add my small input.
Thank you. Okay. So no more from the public? Okay.
May I just say something real
You
quick?
bet. You bet before we get...
To that point of Ms. Peters, when someone's here for one subject and the overflow rooms are full, that is germane to the business of the board and of the public. So that's not anything unreasonable. That's just a lot of people that are upset. And so that just shows the... I don't know, the input from I can't come up with the words. Maybe it just shows their interest in the operations.
Yeah, that's a good point. Yes, Supervisor Miller.
Thank you, Mr. Chairman. I think observation from hearing from the public, and I really appreciate everybody's input. And I'm sorry, I can't remember your name. This young lady sitting here with white jacket on. But she hit... She hit on the one thing that I was taught from my family, my dad, my parents, and everything, was freedom has responsibility. And we have the freedom to drive a car wherever we want, but the responsibility is that we will follow the traffic laws. And if you don't follow the traffic laws, you lose your right to drive. And that's a real simplistic scenario there, but I think that's difficult for some people to really grasp it. That's the responsibility that we take on to allow us to have the freedom that we have in the United States. And so, and I think Josh hit on it a little bit there too. This is the responsibility that we have to have within ourselves to keep our freedom in check and keep our freedom, because if we're not responsible, we will lose our freedom.
Thank you, Chair Ken Falcomer again. I want to begin by apologizing to this board and the public. If, in fact, my words were taken to somehow suggest that I'm minimizing the value of call to the public, that was not my intention. I think the word that an afterthought was probably cavalier on my part. It is, in fact, found in statute. I'm trying my best not to give you my personal opinion. If you ask it, I'll tell you, but I'm trying to be here in official capacity. So I cannot allow you as my client to believe that I am somehow trying to legally persuade you that call the public is not of value, is not of something that should be cherished or honored. And if I gave that impression at the last meeting, I certainly apologize. I also, before you sort of make this decision, I want to give a lot of credit to Madam Clerk. She reached out to all of her colleagues. What I can tell you is that all 15 all boards of supervisors for all 15 counties do in fact have call to the public. 6 of them do it at the end, 8 do it, well, 9, including us, at the beginning. But as of right now, every board of supervisors does in fact have a call to the public. And I'm happy to answer any other questions, but I did want to, I guess, correct and give that bit of information. And again, that's thank you to Madam Clerk. She's the one that looked it up.
Well, I think probably to your point, and the reason why I had the public come up here is because if we're going to move forward on this, or not move forward on having call to the public, I think that it was important that we heard from the public prior to us making any kind of decision, and that's one of the reasons why I opened it up for that. Is there any discussion in regards to this? Because me personally, I'd like to see us move forward with the call to the public, where we put that, how we do it, the bumpers that we put in, just like in bowling, keep us out of the gutter, so on to speak. What can we do? Somebody?
Mr. Chairman?
Yes.
Thank you, Mr. Chairman. I heard a woman speak who's sometimes critical of me, and while it's discomforting for any politician to hear criticism, the right for that person to freely speak in our constitutional republic far exceeds the interest of me to limit any free speech. So I recommend we continue fully with call to the public, and perhaps set it at, an idea is to set it at a time certain during a meeting. If we, rather than front load it, we could say every day at 2:30, we'll stop everything else and have call to the public. That should be just about at the end of the meeting, and we could work out the logistics with the clerk. But I think we should continue with call to the public unabridged and not modify it in any way to limit free speech in any way.
Okay. Supervisor, thank you. Supervisor Surdy.
I think it would be wise to not make any type of decision today. There's way more people watching this online, and will watch it online, and we may get more input through our emails and through our cell phones later. So there's no hurry. I mean, it's been this way for years and years. Let's see what other feedback comes back. And if it ain't broke, don't fix it.
Yeah.
I want to make a couple points about what Mr. Franklin said. This board can be fluid, and we can make a decision next week. We may not like it and switch it right back. Also, something unique about this board and the United States House of Representatives, there can be a complete turnover every election. Whereas city councils, they always have staggered terms so that 3 stay to keep some experience, and you have new ones. And that's the way the U.S. Senate is. You don't have them all expiring at once. It's staggered so that you don't have a drastic turnover. But there could be 5 new people up here next election.
And to that point, they have the ability to change the rules.
Change the rules, yeah.
Yes.
So, I mean, it's not whatever we make here, the next board completely, and to Josh's point, we're not all going to be here. I'll probably die before all of you. But nonetheless, the point I'm getting at, I was going to say Miller, but I decided not to go that route.
The oldest.
But the point is, it'll be the board's decision ultimately to establish the rules and how it's going to go. And so Whatever we do today is not locked in, it's not permanent. And thus, we had this discussion 2 years ago, and this is where we came up with these rules 2 years ago. And so we're just going about. Okay. So Supervisor Miller.
I just have just a thought, and I don't know if it's something that we might do on our call to the public agenda item. We always put it on the agenda that we'll have call to the public, but it might have a little, either a disclaimer that the time may change or it may be altered within the sequence of the meeting due to time constraints or something like that.
Yeah.
Might be a suggestion, because I do agree. I mean, we've all sat as chair, and we get an agenda and we look out there and we go, oh my gosh, how am I going to get through all of this? And the chair should have the flexibility to move it. And I think even we heard from the public suggestions that maybe you do decrease the time because there are so many, So that might be just kind of a disclaimer on the call to the public part that we may have to alter the amount of time.
Allocated based on
based on the business that day.
Well, I did like Mr. Arredondo's suggestion there, which is interesting to think about. If you have time constraints,
Yeah.
and then but by the way, if it overruns that, and you still got people, you could put it at the end of the meeting to move the business along. Say, okay, we have an hour, but it's going to be an hour and a half or 2 hours worth of public comment. So the only issue that I see there is that somebody's going to say they're discriminated against because, oh my gosh, you didn't call me because you don't like me, right? And you stuck me at the end of the meeting. I mean, I'm not saying that would happen, but that's a possibility.
My luck, it would happen.
Well, yeah. Well, up to you, it would happen, but just saying, but that is a possibility.
Okay.
In that frame.
Yeah. Okay. So I think the general consensus of all of us, let's keep going on in this discussion.
But we're not making a decision today. 'Cause
No,
it's not agenda.
but I think
That's what I wanted to clarify.
But I think that it's helpful that if the public hears what this discussion is, like the parameters, the bumpers that we're going to put up, that they hear that and they can have input.
With practice, you don't need the bumpers anymore. By the way, just saying.
I need to practice more.
Responsibility. You don't need bumpers either.
Chair, that is the one thing I do need to make clear, is this is only agendized as a discussion. It was changed to a special meeting just so the public would have the ability to have conversation. It is not agendized for any action, so we cannot take any votes. We can take direction. You can give direction to staff. We can get a consensus. There are certain things that you as the chair can just do as a result of this, but any formal action that the board wants to take via vote would have to be agendized at a future meeting.
Okay. Sounds good.
So, Chair, what I'm hearing is a generalized position that continue this conversation.
Yes.
So I think the next really decision that the board should contemplate giving direction on is when you would like the call of the public to occur. Because depending on that decision, there's other downstream impacts or effects. Again, Madam Clerk pulled these, so what I can tell you is it's easier for me to tell you the entities that hold call of the public, for example, at the end. Apache County, Gila County, Graham County, Maricopa County, Navajo County, and Yavapai County currently hold their call of the public at the end of the meeting.
End of the meeting.
The remaining 9 entities all hold it at the beginning.
Okay.
There appears to be nobody that's sort of middle. And when we say beginning, towards the beginning. I know, for example, we heard Supervisor Kavanaugh say a time certain, and I would invite Madam Clerk to correct me. I'm not aware of any other entity that does that. There's certainly no prohibition against it, but I don't know that any entity that is currently doing that. And we only looked at counties as opposed to our municipal brothers and sisters.
And the problem with putting a time specific, like last week or the time before, we had like 3 cards that were turned in, and only 3 people spoke at that. Most everybody was here to speak on per items, and that's part of where we had a couple of items on there that were pretty controversial, and so we had a lot of people here. Majority of them were to listen to those 2 specific things. We only had 3 people from call to the public come up and speak. And so what the point I'm getting at is if we have a time specific, we don't always get through because I'm a firm believer that when it's an item that needs open hearing, it needs to be a public hearing, the people that want to come and speak should be allowed to speak. And I think everybody here would agree with that because they're here specific for that particular thing. And so I'm not sure of given a time specific. I do like the idea of moving it back a bit so that we can get a lot of the work done. But maybe what we could do is I think it's the town of Queen Creek. They do a call to the public in the beginning, and they allow so much time for that. And then at the very end is additional time for a call to the public. I think I've seen, that's the only time, I think it's the town of Queen Creek. That's the only other time I've seen anything like that.
Chair, just an observation. The vast majority of at least the county employees leave following the consent agenda. Typically, the consent agenda is the largest single agenda item.
Yeah.
There are a number of staff that are typically here. They're here in case this board has questions. If it gets pulled, so there's somebody that has the information. It may make sense to essentially set it after that consent agenda where you could leave. Again, we're certainly not bound by that, but that is just an observation I've made over the last 8 years is about 75% of the room leaves immediately following consent.
And you're, I'm sorry.
Well, I was going to say, that's when we transition to the Public Health Board, the flood district.
Right.
Anyway, so it's a transition period there.
That we could do something like that.
Yeah.
Okay.
So put it after the consent agenda because quite a few, there are members of the public that will call out a consent agenda item to speak.
From time to time.
So from time to time. But that's fine. But they speak to that and then they're done and they go and then do the call to the public after consent, which does get rid of the allows the county staff to leave. Yeah, get back to work.
And we usually don't have a lot of lengthy time on the health or on the flood zone.
Their consent.
Maybe we put it right after those, the consent items, and then those two items, and then put call to the public. Could be it all.
I think that would be a very useful tweak.
Yeah. Okay.
That's worth trying.
Yeah.
And Supervisor Kavanaugh, that would kind of go along with what the time, you're suggesting putting it later on in the day. We've got board meetings that we're done by noon. And by giving it a specific time, that just throws that out.
Yeah.
But what do you think about that, Supervisor Kavanaugh?
I think that's a good idea.
Okay.
And 12:30 is lunch.
Oh, yeah.
I did mention that you get grumpy after that.
Yeah. Don't forget that. We have two strong. We have several strong individuals that are politically charged amidst us, and I mean in our county as a whole, on both sides of the spectrum. And I think it was Mr. Ravelis that just mentioned something about factual. Sometimes we don't. Who does the fact-checking on all of this that allows that? I mean, I don't have time to fact-check anything that's come up here and said, whether it's factual or not. So how would you address that?
Chair, with all due respect, I don't think you can.
Okay.
I believe that's going to be a content-based restriction. Oftentimes, facts are in the eye of the beholder. There's a nugget of truth in there.
Yeah.
And I think if we get into the point where we're saying, hey, we think what you're saying is not true, so we're going to stop you right here, I think you are at that point going to be infringing on First Amendment rights of speakers. I just, as far as truth or non-truths, as far as the public speaking, I'm not sure how you would do it and remain constitutionally compliant.
Okay.
You'd hire Facebook to come and do the fact checking as we're speaking, and they'll just shut you off right now, mic off. Yeah.
Yeah, and some, to your point, what you just said, I'm glad you said that, is that it's in the eyes of the beholder for a lot of these things, and perception is 90% of life for people, and their perception is usually skewed. I mean, let's be real. Even I've been skewed. Ask my wife; she'll tell you. And so those type of things is okay. I get that. I don't want to limit anybody from being able to come up and give their viewpoints and things of that nature, not necessarily. So, okay. All right, so I think we've established where we might want to put it, right? And then what else is there to bring up?
I'm sorry, just to be clear, Mr. Chair, so we talked about placing the call after the consent and say flood, health, et cetera, those things, and then call?
Yeah.
That way the other 14 counties can copy us.
Yeah, what we could, but the other
Trendsetters.
But still, sometimes we have a lot of, like what we did the week before. We had 2 particular items that people were here to specifically speak of, and there was the group from the Johnson Ranch area that sat here through everything. They were like number 13 or 14, and they had to sit here for 2 or 3 hours. Some of them even left because they had to go to work or whatever the case may be. And so, in a way, it's not fair to those individuals when there's a lot there and they're here to express themselves. Go ahead, Supervisor Miller.
Well, I thank you, Mr. Chairman. That's where the chair has the flexibility to adjust,
To move it around.
and I think that I just hope that that's always is the rule. That because just like anything, you have to manage the meeting at some level, and to be efficient and fair. The chair has to have the authority and the ability to adjust the agenda.
So it's my fault.
That's not your fault. It's your job.
I'm kidding.
It's not your fault. It's your job.
I'm kidding.
But
Okay.
I mean, don't
Right,
I mean, don't
right.
you agree? I mean, you might just one day say, I know we have it after public health, the call to the public, but today I'm going to move it up, or I'm going to have to move it down, or you
Okay.
know. I mean, if you have that ability, that's all you really need.
Supervisor Sturdy, you want to weigh in on that?
No, I think,
Okay.
yeah, I like the idea of right after consent gets a lot of this stuff
It
out of
does
the
clear the
way.
house a bit, yeah.
Yeah, in case,
And that's,
in
okay.
case it does drag on during call to the public.
Yeah, okay. Okay, so
Chair,
got some
if
direction
that's,
there, right?
you have absolute discretion. Supervisor Miller is correct. I would suggest it may make sense for you to direct staff if they know that there's an agenda item upcoming, that there's going to be a lot of public outcry or participation, that perhaps they notify the chair so the chair is at least aware of it. Sometimes we can guess and like, oh, there's going to be 25 people here. Other time when we walk in and I'm like,
yeah.
what are all these people here for? So you certainly would be well within your purview just to ask staff if they're aware of it. And it tends to be more along the line of zoning or ordinances or SUPs and those type of things, but not always. Sometimes there are other issues. But if staff's aware of it, you can certainly give direction to notify both Madam Clerk as well as the chair so you can make those appropriate adjustments.
Okay. Supervisor Kavanaugh, did you have any comments on that?
Nothing further.
Okay. Okay, should we, where do you want to go from here then?
This is kind of the meat. This is how you want to actually restrict or not restrict call to the public in the way that people specifically are able to address the board.
Is this the designated or limited part?
Correct. And by making it a call to the public, you have effectively at this point made it a limited. So you do have some ability to put restrictions. The designated, no restrictions, all hands off. Now, you can still choose to treat it in that respect and just say, hey, we're going to allow anything and everything to go. But I do want to address 2 things right now. There was a speaker, and George, I apologize, I don't remember his last name, and I hate calling people out, but he specifically said, hey, there are no restrictions. There actually are. There are 2 restrictions. There are restrictions for you as board members that you've agreed to, and there are restrictions on the public at large, and I'm just going to go over them kind of real quickly with you. So on the Pinal County Board of Supervisors Board Meeting Rules of Orders, which were signed by then Chairman Mr. McClure on November 16th of 2022, there is a specific provision in which your behavior is limited by subsection C by your own agreements, and that is no member shall indulge in personal attacks. No member shall indulge in personal attacks, impugn motives of members, staff, or the public, or use language tending to hold a member up in contempt. So that is sort of the restriction on you as board members.
So what classifies a personal attack? I remember Supervisor Miller made a comment about this is a clown show. Is that, I mean, that didn't sound like a personal attack to me.
I would suggest that that's in the eye of the beholder, and ultimately the arbiter would be the chair. The way that this system is set up is we vest a lot of power and authority, especially to make a meeting run smooth. That power, by your rules and adoptions, vests that authority within the chair. So if the chair deems it to be a personal attack, essentially the chair should have to declare that. That's a personal attack. That's inappropriate. I'm directing you to stop.
Okay. And what would have been appropriate in that particular situation whenever the point of order was called was to actually stop and look and ask, what's your point of order, and get their definition of it, and then move forward.
Correct.
Whether you rule on it or not, one way or the other, you're ruling on it.
Yeah, you have to rule on it. So if there's a point of order made, you should give the opportunity
Okay.
for that person to make the point and then make your decision. And
Okay.
again, pursuant to subsection B, it doesn't require a second, and the chairperson's final decision is final unless there's an appeal, and then it would be the board.
Okay.
So what it could go is, I'll use Supervisor Surdy. He says, point of order, this is out of control. And you as the chair say, no, I don't agree. Proceed forward. He could say, I'm asking for an appeal, and if 3 of the board members all agree that we're out of control, then we'd have to move on. But it
Okay.
would, it's almost instantaneous the way that it's designed, because we don't want to have to take breaks and go into executive session.
Right,
We
right.
want it to be able to transpire as smoothly as possible. But the board gets to make that immediate decision, and the appeal only occurs if there's a majority
Okay.
to overrule.
Go ahead.
When I was chairman, I actually got criticized for not gaveling people. Do you remember that?
Yes.
You going to rub it in?
No.
So, Chair, that is the restrictions on you. There are separately rules that were adopted by this board under the call to public. And normally they are posted, I believe, on the screen when call to the public comes up. And it is specifically paragraph number 5.
Okay.
It's in your drawer.
So number 5 says, in order to maintain civility and respect for all points of view, there will be no clapping, booing, or any other verbal form of support or non-support. I think Mr. Arredondo had addressed that. Any person making personal, impertinent, or slanderous remarks, or who becomes boisterous while addressing the board, shall be asked to refrain from such, and if they refuse and continue, may be removed at the discretion of the chairperson. Continued unauthorized remarks from the audience, stamping of feet, whistling, yelling, booing, clapping, cheering, or similar demonstrations may be grounds for a removal. So that is our behavioral restriction, if you will. That behavioral restriction is consistent, if you wish to keep it, with the opinion that was authored by then Attorney General Janet Napolitano. Essentially, when she was issued this opinion, she looked at what are reasonable restrictions that can be placed. Number 1 is time limits. We've discussed that. That is sort of a foregone conclusion. You can either limit the entirety or individual members, as long as you don't say, a Republican gets 3 minutes, a Democrat gets 2, a communist gets 1. You can't make those sort of arbitrary restrictions. It has to be across the board, otherwise you're allowed to set those. There's also banning repetition. Supervisor McClure, you addressed that while you were chair, where you had 30 people that are all speaking in favor. The board does have the ability to say, look, we're not going to listen to an hour of people say the same thing over and over, so you can limit their repetitive comments and ask that they address something new. But the third area that the general pot is prohibiting disruptive behavior. And that's where that restriction comes from. The way that then AG Napolitano states it is including words that likely to provoke immediate combat or speech that exceeds preset time limits, unduly repetitive, or extends discussion by irrelevances. This serves a significant government interest in preventing actions that block a public body from accomplishing its business in a reasonably efficient manner. Again, I'm not trying to call people out, but it was Mr. Arredondo who brought up very specifically saying, hey, the rules need to be enforced equally. This is a rule that exists that has, to the gentleman behind me's points, never really been enforced. That is what my concern is. You can't have laws and not enforce those laws. So either we want to be able to restrict it, and if you do, you're going to have to state why you have a compelling governmental interest, or you need to remove that. Because the idea of having a rule, having you can't do this, and then letting people do it, that becomes arbitrary. It becomes arbitrary and capricious, and then we get into all kinds of trouble. So that is why I brought it up. It's there, and again, in my 8 years, I don't know that I've ever seen anybody, maybe one time. I think maybe there was one time where the board said that's inappropriate. But generally, this board, regardless of who our chair has been willing to allow people to have their say with very, very limited interruption. That's perfectly fine. But if you're going to keep a rule like this, then you need to start enforcing it. And that's a policy decision that I think this board needs to make.
Okay.
There's one final thing that I would like to touch on before I give up the mic, and that is regarding public meetings and that sort of end around that was addressed. So members of the public body shall not discuss or take legal action on matters raised during open call to the public unless matters are properly noticed for the discussion and legal action. That's what I was talking about when we were talking about the end around, just to be clear. So that's why if it's a criticism, you're allowed to address the criticism, but the call to the public cannot create a separate conversation. It can't.
So
that is statutorily prohibited.
All right, let me give you an example. Here a few weeks ago, we had a situation where one of our board members was called out, or it appeared to be that way. There was no criticism given, and he responded to it, and it was something. It was in regards to something that he had asked me before. In regards to that, to put it on an agenda. Help me understand that.
So this board has adopted what has sort of informally been called the rules of engagement. And that's essentially saying, look, the board can respond, but only in the event that they've been criticized. That rule, again, comes from subsection I of our statute. It specifically says, individual members of the public body may respond to criticism made by those who have addressed the public body.
Okay.
So it is, by statute, that ability to speak and that sort of, I guess, sort of an end around or that opening in the board being able to address a non-agendized item is very specific, and it is specifically criticism. This board, in my estimation, has become less than diligent in making sure that it's criticism that they're responding to. And I don't want that to come off as I'm somehow shaming you, but sometimes it's something very, very similar. Supervisor Miller, I think there was an example where there was somebody that was frustrated with, I don't know, it was like a lean-to or something. And they said, Mr. Miller was great. He was really helpful. This was outstanding. And Mr. Miller responded to it saying, yeah, we always like to be able to help people. It was that type of thing. It was a very kind conversation, and on its face, it didn't seem inappropriate. But that got really close. And that there's sort of this gap that's been opening. And my responsibility is to do my best to keep you within the statutory limitations. The statutory limitation for you to address and to talk to the public about any particular issue, it must come from criticism. That's what our state statute says. Criticism and criticism only. So the example that you gave, Supervisor Goodman, at that point I was sort of, I'm not sure how to handle it, and that's my fault. I should have been more prepared to step up and say, look, that's not a criticism. That's not a permissible opportunity to have the conversation. In fairness, I don't blame any of the board members because I don't know that we've ever really had this conversation. And if we did, it would have been 4 years ago when you swear in and we do that little like half a day where we just bombard you with information. That's part of the reason why we wanted to have this conversation so the board is aware of that.
Supervisor Miller.
I'm glad you brought that up because when I was asked, do you want to respond? And I even hesitated for a second, but then I said, the person took my advice and contacted the right person. Now, that's all I thought I did. Now, was that close to engaging? I mean, just saying, hey, they followed my advice?
So, look, do I think anybody's ever going to come after you and file a formal open meeting law complaint against you for that? Probably not. But in a way, you sort of did give advice to them. You said, hey, follow my advice. So in a way, you sort of did give direction to them and anybody
That was
listening.
in my office. I mean, that was a meeting.
Right, but from the dais, you said that.
From the dais, yeah.
Look, we're getting into really murky ground. I apologize. I didn't mean to speak over you.
because I won't respond to that again. If that's the case, I thought I was covering myself by saying they took my advice from the office. In other words, they
Right.
came to my office. I told them this is what you need to do, and they did it, and it resolved their issue.
I'm not trying to criticize you, and if that came across as criticism,
Well, if that's criticism, I want to respond to that. So,
I don't want. I'm not taking it as.
but to that point, I mean, if he just said, "Oh, thank you," period,
No-
right?
no concerns with
But
that.
like, stop, just shut it off. Right?
But that sort of, and again, I'm not suggesting you did that, but that's what happens when you come and talk with me. That sort of, it bolsters yourself. It arguably gives direction to other people how to get things resolved. That's when you start to get, again, we get a little bit nervous about it. Again, I would never prosecute. I have the ability to prosecute these and say, hey, this is a violation. Or I can refer it to the AG's office and say, Attorney General, I think you violated it. That's not to the point because there wasn't anything there, but I'm just using, it's a creep, I guess is how we just keep creeping a little bit more to the point where we sort of now, if they say your name, it's like, hey, and again, that's the cordial societal thing to do. Somebody says something to you, they compliment you, you tell them thank you. And normally not just a curt thank you, because then it's like, oh, well, that didn't really mean anything. You want to give them a meaningful interaction. I understand and appreciate it. I'm just cautioning you, we need to be very careful on those non-agendized items, because there could be somebody that doesn't maybe interpret it the way we do, or it could file a formal complaint. Again, your interaction, I don't think crossed that line. I think the interaction we talked about before probably did.
And I paused. I mean, I really did, because I thought, how am I going to answer this? And I thought just by saying they followed my advice, I thought that was safe.
I'd like to ask Chris if he has any, he's been doing this particular issue much longer than I have.
He didn't shoot me with a rubber band or anything that day.
And frankly, it is a delicate balance that
Sure.
when we're sitting on this side,
Yeah.
where you don't necessarily know where you're going or what you're going
Right.
to say, a pleasant thank you is fine. It's the balance of, will this conversation now continue and
Sure.
morph into something a little bit more that was never on the agenda, so that somebody else in the public said, hey, if I had known that you were going to talk about that, I would have come down, because I have my 2 cents I want to put in about that. I was at Mr. Miller's office, and he didn't give me any advice.
I was the one that complained about how ugly that shed was, for example, or whatnot.
But
Yeah,
I think, Kent,
Yeah.
I think
correctly, it's the creep value. It could be creeping and morphing a little bit more.
Sure.
And we just need to be cautious as to not expanding that dialogue with the public at all.
Right.
Okay.
Okay.
And the last thing I
I'm
would
glad you
leave,
brought it up, because I do remember it.
the last thing I would lead you with is any restrictions that you want to place. If it is specifically about the content, we need to have a further conversation about why there's a legitimate governmental interest. So you have the ability, for example, Supervisor McClure had alluded to, I think they should only talk about things that are, within our purview. I believe, my words, not yours,
Right.
but to that effect. That is a restriction, but you are necessarily preventing other things from happening. We would then have to have a conversation about specifically why. Frankly, I would recommend that we set that as an agenda item in the future, and that you make actual findings to say this is why we believe that we have a significant governmental interest in it. Anytime you are trying to restrict free speech, particularly, as I told you, coming to the 50s to now, there are less restrictions that are available now that once were. In fact, all restrictions are looked at under a heightened scrutiny. Like, why is the government afraid to be criticized? Why is the government limiting the content of what I want to say? Why are they violating my First Amendment speech? So any of those restrictions that you are contemplating, I think this is a great starting point, but I think there needs to probably be a second meeting.
Yeah, and I think part of that second meeting, we should be talking a little bit about the agendas, how they function, how do you get things put on the agenda, those type of things, and what's appropriate, what's not appropriate on the agendas. So I think that should be part of the other conversation. And I think now that the public knows that we've talked about this, and I think we'll get some response back. Supervisor Miller.
Yeah, I'm glad you brought that up, because I do have people from the public that want to put things on the agenda. And I think that process should be laid out a little clearer, because, I usually say, get a hold of Natasha, see what she can do, those types of things, or the county manager's office. But because I say, yeah, we probably should put that on the agenda so we can all talk about it, because I don't know where my colleagues would be with that.
Chair, Supervisor Miller, I can't tell you this is the case now, but about 2 years ago, we sort of did an analysis of everybody in Mojave County at that time, allowed anybody to put an agenda item on. Any staff member from the county, any member from the public, anybody could just agendize anything. Wow. I don't know that they're still doing that. I don't know the fallout of that. But at one point, there was a county that just said, hey, that's not the way it works. Under our current system, as the rules that are adopted, the chair is sort of the thumbs up, thumbs down.
Yeah.
Okay.
Yeah.
Is there any further comments or questions from any members of the board? Okay.
I do think the public had some more conversation. At least that was on their first statements. I'm not suggesting you need to, but because it's not a public hearing, we don't have the sort of firm one bite at the apple.
No, but I like that idea. Now that you've heard some more discussions, does anybody else want to add anything? I think Mr. Ravelis, come on up.
Roberto Ravelis, resident of Gold Canyon, and parenthetically, I am the eldest elder in the room. So I speak from a sense of experience. Sometimes that misleads me, but most of the time it enlightens me. And as an avowed civil libertarian, I would be the last person to suggest that the chairman or the board adopt any restriction based on the content of a person exercising their First Amendment. And we thoroughly agree, even though you've heard a couple of us disagree on issues, we thoroughly agree in a brief conversation we had before this. So I think you've done a remarkably good job in opening up this for the agenda. So thank you again.
Thank you. Is there?
Don't say anything else.
Come on.
I just want to say that I agree 100% with Mr. Ravelis, so this may never happen again. He's right.
Well, that's good.
That's good.
Yes, ma'am.
Found some common ground.
Well, we did something good today then, it sounds like.
I'm still Dia Podolsky, and there was another point that I wanted to make, and I'm leaving, so I'm not going to have an opportunity. I think there will be other opportunities given, but I'm going to be kind of away until the election. But you've talked about it, you've alluded to it, that particularly Supervisor McClure, that what we discuss and call to the public should have some connection, even if it's tangential, to things that you have agency over. And I even came up with 2 examples. I think that it would be very appropriate and call to the public for me to get up and encourage you to increase the budget for animal control in Pinal County. You can do that. You could hire more officers. It would be inappropriate for me to get up and tell you about my dog and how sad I was when my dog died when I was 6, and how it was the most crushing experience of my life. That's pretty inappropriate. You might sympathize with me, you might agree with me, but it doesn't have anything to do with the business of Pinal County. The other one was clothing. I think it would be very appropriate for you to seek out grants to buy clothing or provide clothing to people in things like the diversion program that are going out for job interviews and have nothing to wear. And I could advocate for that. I could suggest to you grants available. It would be inappropriate for me to tell you how beautiful I looked in my senior prom gown. That is inappropriate. And I think it has to do with the emphasis on whether the speaker is talking about the county or the speaker is just talking to rant. And that's all I have to say, because as I said, I'm not going to be around, but I do think that you have that obligation to at some point say, no, that's totally off base. And as an English teacher, I know you can tie almost anything to anything. So, all this little thought that the person is going to make for their that statement. Thank you.
Thank you.
Those are good examples.
Those are really good examples. Anybody else would like to have a second word? Okay, seeing that there's none.
Did we want to direct staff, or
Did we-
it's a discussion, but you had the option to direct staff to do?
Well, I think the direction, is we're not making a decision today. Let's look these over as a board. Maybe staff, if you've got some ideas or whatever, so that we can tighten some, and then the agendas. But as we get input from the public on some of this, and if those of you that have spoke here, if you want to send something in writing, and then you can make sure that all of us get a copy of whatever's written, that'd be great.
Yes, Chairman, if they can just send that to the clerk of the board at pinal.gov, I will make sure that that information is distributed to the whole entire board.
Okay, because at some point we need to, yes, Supervisor Kavanaugh.
Forgive me. I think it's a good idea to have the chairman, when during calls to the public, when he refers to another supervisor in response, the assumption is a criticism has been made. So I think it's incumbent upon the chair to make the call that a criticism has been made. If a board member feels that the chair is incorrect, then the board member should say so, that, hey, I believe that was a criticism and here's why. But I think the chairman should be the referee of the criticism.
Okay, fair enough. Okay, that's something that we ought to look at.
It's your fault again.
Yeah, and I think at this point that really is the case. The chairman is the one that determines whether or not there's a criticism has been made. Okay, with that then, we're adjourned. Would have had a lot more people.